All right, welcome back to the Daily Facts. Today we're going to go over the Office of the Inspector General's review of 4 FISA applications and other aspects of the FBI's Crossfire hurricane investigation. Before we get into the actual document, I'm going to play the clip of Inspector General Horowitz with his opening statement. When we come back, we'll delve into the actual review of 4 FISA applications and other aspects of the FBI's Crossfire hurricane investigation report.
Thank you, Mr. Chairman, Ranking Member Feinstein, members of the committee. Thank you for inviting me to testify today. Our 500-plus page report provides a thorough, comprehensive, and objective recitation of the facts related to the departments and the FBI's handling of the Clinton email investigation. It was the product of 17 months of investigative work by a dedicated OIG team that reviewed well over 1.2 million documents and interviewed more than 100 witnesses, many on multiple occasions. The review team followed the evidence wherever it led, and through their efforts, we identified the inappropriate text and instant messages discussed in the report. Additionally, the OIG's painstaking forensic examinations recovered thousands of text messages that otherwise would have been lost or undisclosed. As detailed in our report, we found that the inappropriate political messages we uncovered cast a cloud over the mid-year investigation, sowed doubt about the credibility of the FBI's handling of it, and impacted the reputation of the FBI. We found the implication that senior FBI employees would be willing to take official action to impact a presidential candidate's electoral prospects to be deeply troubling and antithetical to the core values of the FBI and the Justice Department. With regard to the decision to close the investigation without prosecution, we found no evidence that the conclusions by the prosecutors were the result of improper considerations, including political bias, but rather were exercises of prosecutorial discretion by the prosecutors based on their assessment of the facts, the law, and past department practice. Our review also included a fact-based detailed assessment of certain specific investigative and prosecutorial decisions that were the subject of controversy. It was necessary to select particular investigative decisions because it would not have been possible to recreate and analyze every decision made in a year-long investigation. In examining these decisions, the question we considered was not whether a particular decision was the most effective choice, but rather whether the documentary and testimonial evidence indicated the decision was based on improper considerations, including political bias. This approach is consistent with the OIG's handling of such questions in past reviews when assessing discretionary judgment calls, and recognizes and respects the institutional oversight role of the OIG. Our report provides a comprehensive assessment of these decisions and of the mid-year investigation and details the factual evidence so that the public, Congress, and other stakeholders can conduct their own assessment of them. Within this framework, as to the specific investigative and prosecutive decisions we reviewed, we did not find documentary or testimonial evidence that improper considerations, including political bias, directly affected those specific decisions, in part because the decisions were made by the larger mid-year team or the prosecutors. This determination by the OIG, as I noted, does not mean that we necessarily endorse the decisions or conclude they were the most effective options among those considered, or that our finding should or can be extrapolated to cover other decisions made during the course of the investigation by the FBI employees who sent these inappropriate text messages. Conversely, we found the FBI's explanations for its failures to take immediate action after discovering the Wiener laptop in October 2016 to be unpersuasive, and we did not have confidence that the decision of Deputy Assistant Director Strzok to prioritize the Russia investigation over following up on the Wiener laptop was free from bias in light of his text messages. We also found that in key moments, then FBI Director Comey clearly departed from FBI and department norms. and his decisions negatively impacted the perception of the FBI and the Justice Department as fair administrators of justice. Director Comey concealed from the Attorney General and the Deputy Attorney General his intention to make a unilateral announcement in July 2016 about the reasons for his recommendation not to prosecute former Secretary Clinton. His July 5th statement included inappropriate commentary about uncharged conduct, announced his views on what a quote-unquote reasonable prosecutor would do, and served to confuse rather than clarify public understanding of his recommendation. In late October, he again acted without adequately consulting department leadership and contrary to important department norms when he sent a letter to Congress announcing renewed investigative activity days before the election. There are many lessons to be learned from the department's and the FBI's handling of the mid-year investigation. But among the most important is the need to respect the institution's hierarchies and structures and to follow established policies, procedures, and norms, even in the highest profile and most challenging investigations. No rule, policy, or practice is perfect, of course, but at the same time, neither is any individual's ability to make judgments under pressure or in what may seem like unique circumstances. When leaders and officials adhere to bedrock principles and values, the public has greater confidence in the fairness and rightness of their decisions, and those institutions' leaders better protect the interests of federal law enforcement and the dedicated professionals who serve us all. By contrast, the public's trust is negatively impacted when law enforcement officials make statements reflecting bias, when leaders abandon institutional norms and the organizational hierarchy in favor of their own ad hoc judgments, and when the leadership of the department and the FBI are unable to speak directly with one another for the good of the institutions. Our report makes 9 recommendations, most of which can be tied together through a common theme, that the FBI and the Justice Department remain true to their foundational principles and values in all their work. That concludes my prepared statement. I'd be pleased to answer the committee's questions.
All right. So we heard from the Inspector General, and that just gives you an idea of, the individual that put the report together, the lead, which was an IG Horowitz, and and his points. And now we're going to go ahead and start reading the report. Now, keep in mind, this is the redacted release for public consumption. Okay, so we're going to get right into it. The executive summary, this is page 1. So we're going to start with the background. The Department of Justice, Office of the Inspector General, undertook this review to examine certain actions by the Federal Bureau of Investigation and the department during an FBI investigation opened on July 31st, 2016, known as Crossfire Hurricane, into whether individuals associated with the Donald J. Trump for President campaign were coordinating wittingly or unwittingly with the Russian government's efforts to interfere in the 2016 U.S. presidential election. Our review included examining, the first one, the decision to open Crossfire Hurricane and 4 individual cases on current and former members of the Trump campaign: George Papadopoulos, Carter Page, Paul Manafort, and Michael Flynn, the early investigative steps taken, and whether the openings and early steps compiled with Department and FBI policies. The FBI relationship with Christopher Steele, whom the FBI considered to be a confidential human source, its receipt, use, and evaluation of election reports from Steele, and its decision to close Steele as an FBI CHS. The 4 applications filed with the Foreign Intelligence Surveillance Court in 2016 and 2017 to conduct Foreign Intelligence Surveillance Act surveillance targeting Carter Page, and whether these applications compiled with Department and FBI policies and satisfy the government's obligations to the FISC. The interactions of Department Attorney Bruce Orr with Steele, the FBI, Glenn Simpson of Fusion GPS, and the State Department, whether work or spouse performed for Fusion GPS, implicated ethical rules applicable to Orr and Orr's interactions with department attorneys regarding the Manafort criminal case, and the FBI's use of undercover employees and CHSs other than Steele in the Crossfire hurricane investigation, whether the FBI placed any CHS within the Trump campaign or tasked any CHS to report on the Trump campaign, whether the use of CHS and UCEs compiled with department and FBI policies, and the attendance of a Crossfire hurricane supervisory agent, counterintelligence briefings given to the 2016 presidential candidates and certain campaign advisors. Okay, now we're going to move over to the OIG methodology. The OIG examined more than 1 million documents that were in the department's and FBI's possession and conducted over 170 interviews involving more than 100 witnesses. These witnesses included former FBI Director Comey, former Attorney General Loretta Lynch, former Deputy Attorney General Sally Yates, former DAG Rod Rosenstein, former acting AG and acting DAG and current FBI General Counsel Dana Buente, former FBI Director Andrew McCabe, former FBI General Counsel James Baker, the Department Attorney Bruce Orr, and his wife. The OIG also interviewed Christopher Steele and current and former employees of other U.S. government agencies. Two witnesses, Glenn Simpson and Jonathan Weiner, a former Department of State official, declined our request for voluntary interviews, and we were unable to compel their testimony. We were given broad access to relevant materials by the department and the FBI. In addition, we reviewed relevant information that other U.S. government agencies provided the FBI in the course of the Crossfire hurricane investigation. However, because the activities of other agencies are outside our jurisdiction, we did not seek to obtain records from them that the FBI never received or reviewed, except for a limited amount of State Department records relating to Steele. We also did not seek to assess any actions other agencies may have taken. Additionally, our review did not independently seek to determine whether cooperation existed for the Steele election reporting. Rather, our interview was focused on information that was available to the FBI concerning Steele's reports prior to and during the pendency of the Carter Page FISA authority. Our role in this review was not to second-guess discretionary judgments by department personnel about whether to open an investigation or specific judgment calls made during the course of an investigation, where those decisions compiled with or were authorized department rules, policies, or procedures. We do not criticize particular decisions merely because we might have recommended a different investigative strategy or tactic based on the facts learned during our investigation. The question we considered was not whether a particular investigative decision was ideal or could have been handled more effectively, but rather whether the department and the FBI compiled with applicable legal requirements, policies, and procedures in taking the actions we reviewed, or alternatively, whether the circumstances surrounding the decision indicated that it was based on inaccurate or incomplete information or considerations other than the merits of the investigation. If the explanations were given for a particular decision were consistent with legal requirements, policies, procedures, and not unreasonable, we did not conclude that the decision was based on improper considerations in the absence of documentary or testimonial evidence to the contrary. The opening of Crossfire Hurricane and 4 related investigations and early investigative steps. The opening of Crossfire Hurricane and 4 individual cases. As we described in Chapter 3, the FBI opened Crossfire Hurricane in July 31st, 2016, just days after its receipt of information from a friendly foreign government reporting that in May 2016, during a meeting with the FFG, then Trump campaign foreign policy advisor George Papadopoulos suggested the Trump team, had received some kind of suggestion from Russia that it could assist this process with the anonymous release of information during the campaign that would be damaging to Ms. Clinton and President Obama. The FBI Electronic Communication (EC) opening the Crossfire Hurricane investigation stated that based on the FFG information, this investigation is being opened to determine whether individuals associated with the Trump campaign are witting of and or coordinating activities with the government of Russia. We did not find information in FBI or Department EC's emails or other documents or through witness testimony indicating that any information other than the FFG information was relied upon to predicate the opening of the Crossfire Hurricane investigation. Although not mentioned in the EC, at the time, FBI officials involved in opening the investigation had reason to believe that Russia may have been connected to the WikiLeaks disclosures that occurred early in July 2016 and were aware of information regarding Russia's efforts to interfere with the 2016 U.S. elections. These officials, though, did not become aware of Steele's election reporting until weeks after, and we therefore determined that Steele's reports played no role in the Crossfire Hurricane opening. The FBI assembled a headquarters-based investigative team of special agents and analysts and supervisory special agents referred to throughout this report as the Crossfire Hurricane team, who conducted an initial analysis of links between Trump campaign members and Russia. Based upon this analysis, the Crossfire Hurricane team opened individual cases in August 2016 on 4 U.S. persons: Papadopoulos, Carter Page, Paul Manafort, and Michael Flynn, all of whom were affiliated with the Trump campaign at the time the cases were opened. As detailed in Chapter 2, the Attorney General's Guidelines for Domestic Operations, AG Guidelines, and the FBI's Domestic Investigations Operations Guide, DIOG, both require that FBI investigations be undertaken for an authorized purpose, that is, to detect, obtain information about, or prevent or protect against federal crimes or threats to the national security or to collect foreign intelligence. Additionally, both the AG Guidelines and the DIOG permit the FBI to conduct an investigation even if it might impact First Amendment or other constitutionally protected activity, so long as there is some legitimate law enforcement purpose associated with the investigation. In addition to requiring an authorized purpose, FBI investigations must have adequate factual predication before being initiated. The predication requirement is not a legal requirement, but rather a prudential one imposed by department and FBI policy. The DIOG provides for two types of investigations: preliminary investigations and full investigations. A preliminary investigation may be opened based upon any allegation or information indicative of possible criminal activity or threats to the national security. A full investigation may be opened based upon a articulable factual basis that reasonably indicates any one of three defined circumstances exists, including an activity consisting a federal crime or a threat to the national security has, may, or have occurred, or may be occurring, or may occur, and the investigation may obtain information relating to the activity or the involvement or role of the individual group or organization in such activity. In full investigations such as Crossfire Hurricane, all lawful investigative methods are allowed. In preliminary investigations, all lawful investigative methods, including the use of CHSs and UCEs, are permitted except for mail opening, physical searches requiring a search warrant, electronic surveillance requiring a judicial order or warrant, Title III wiretap or FISA order, or requests under Title VI or FISA. I'm sorry, Title VII or FISA. An investigation opened as a preliminary investigation may be converted subsequently to a full investigation if information becomes available that meets the predication standard. As we described in the report, all of the investigative actions taken by the Crossfire Hurricane team from the date the case was opened on July 31st, October 21, until October 21, the date of the first FISA order, would have been permitted whether the case was opened as a preliminary or full investigation. Okay, we'll end there and we'll pick up on part 2 soon. Thanks for stopping by the Daily Facts. We'll talk again later. Bye.